know you're first, you front and center. So what I intend to do is the chairman is presenting another bill in a different committee, and what he asked me to do was to take Representative Turner's bill first, 969. We'll do that first, and then because we all love Representative Nimmer, we're going to do his bills next. And you have three of them, and we're just going to let you pick which one you want. All right, okay. So that's the way we'll handle it, and then if the chairman's not here by the time we get through with that, we'll just make it up as we go. So, if y'all would, bow your heads with me, and we'll begin this meeting with a word of prayer. Lord, we thank you once again for letting us meet here in this democracy. We ask you to give this Judiciary Committee the wisdom to know how to handle all the matters that come before us and do what's best for the people of Georgia. We thank you for all the blessings we have in this great country. Amen. All right, Representative Turner, you are first, and so we have House Bill 969. Go ahead.
Chairman, members of the committee, I bring before you HB 969, LC number 297931. This is a second bite of our apple, if we will, the compromise measure for civil asset forfeiture reform for the session. It does something very simple. Just raises the state's burden of proof from a preponderance of the evidence to clear and convincing evidence. I believe the members of this committee use those terms all the time, so I will leave it at that and ask if there are any questions from the committee.
Okay. Any questions from members of the committee for Representative Turner on House Bill 969? Are those the only two spots where clear and what preponderance of the evidence is in the civil forfeiture?
According to Ms. Travis in Legislative Council, that is correct.
Okay. What do you think will be the result of this change?
I think it levels the playing field a little bit. I believe that the evidentiary standard of preponderance of the evidence is really low for these measures, especially since no conviction is required before the state moves to these proceedings. And so I believe meeting a little bit of a tougher standard is more fair to the property owner.
Okay. All right. The only person that I see, well, actually we have two people signed up. House Bill 969. First, let's bring forth the first person I'm having is David Cook with the DA's Association. Ms. Turner, you don't have to move. You can just slide over maybe and let Mr. Turner come up there in case there are any questions as we go through it. Mr. Cook, welcome. Tell us who you are and who you're with, and happy to have you today.
Thank you, Mr. Chairman. My name is David Cook, and I'm the elected district attorney in Macon, Georgia.
Okay.
I'm a career prosecutor. I've been doing this over 20 years, and I'm here not only in my personal capacity, but also representing the District Attorneys Association.
Okay.
So we're opposed to this bill. Basically, we just had a significant rewrite 2 years ago, which y'all are all aware of. And one major part of that in why the DAs and all of the law enforcement agencies signed on in cooperation with that reform was that we kept the same standard of preponderance of the evidence that's used in all civil cases, and it's also the same standard that's used by 31 states and the federal government when they have the same type of action. So simply put, this is the standard we want to keep when we seek to go after property that's profits of crime or property that was used to facilitate crime. So based on that, we think we should keep the same standard that we already have, especially since we just went through this a couple years ago.
Okay.
And I'm open to any questions you may have.
Well, we appreciate you being here today. Any questions of District Attorney David Cook? It's Macon Judicial Circuit, is
That's
that
correct.
Is that what they call it, Macon? Or
Yes, it's the Macon Judicial Circuit. And I will point out that we've used this quite a bit in my circuit. We've had a number of establishments that have adversely affected my constituents. They've asked me to take action, particularly with respect to the gambling industry and the addictive causes there that's economically hurt a number of families in my jurisdiction.
So Macon, that's Macon-Bibb County?
Yes,
Yeah.
so that's Bibb, Crawford, and Peach counties. I represent about 200,000 people.
Okay. And are you Democrat or Republican?
Well, I run as a Democrat.
Okay. All right.
But I can
That's
tell
fine.
you that all of the DAs,
We like our Democrats here.
There
We
you
like
go.
'em,
He
yeah.
has a Republican cousin up here, though.
Oh, who's
Kevin
that?
Cook.
Us.
Oh,
Yes.
Kevin's your cousin. Okay.
Yes,
All
yes.
right,
So
okay.
Kevin is my first cousin.
All right.
But I can tell you that regardless of party, that the DAs are opposed to this.
Okay. Thank you very much. Well, we appreciate any questions from the committee. Thank you. We
Thank you so
appreciate
much.
you coming up today. The other person that I have signed up for 969 is Nathan Humphrey with NFIB.
I can speak from right here, Mr. Chairman. We represent small business in Georgia, and we're in support of the bill. I think it's a good, moderate compromise.
Why do y'all support the bill? Why don't you come on up?
Excuse me. Thank you, Mr. Chairman, members of the committee. We think it's a good compromise because it gives a little more protections to citizens and business owners in Georgia that are in situations like this. A lot of times, small business owners, their property, it's the gray area where their personal property is also their business property too. So it puts them in a difficult situation at times, and I think this is a good moderate step that just gives it a little more protection to those individuals.
Do you have members of your organization that have had any problems with this?
Yes, sir, I have, and they have been in that position, and that's kind of one of the reasons why this issue has come to the forefront. We've also balloted this question to our members. We have 7,600 members across Georgia, and it came back 82% are in favor of making some reforms on civil asset forfeiture.
Representative Kelly, did you have a question?
I do. I was going to just ask Nathan to elaborate a little bit more on specific examples where legal businesses were impacted by this. Because when I talked to my DA, when I talked to my sheriff, I would just be concerned if your 7,600 members were made up of drug dealers and gangbangers.
Right, absolutely. And first of all, let me be very, very clear. I do not want to do anything to do away with civil asset forfeiture. I think it's a very important tool that the law enforcement needs. So, and that's the reason why I think this bill is good. It doesn't do away with civil asset forfeiture. It doesn't do anything. It just gives a little more protection, raising the burden of proof when there's
Which
a
is
business.
everything in a court hearing. I mean, burdens of proof determine whether something is really feasible to get done and to prosecute versus when something is almost nearly impossible of a burden to meet.
Sure.
And so that is my concern here, is that we're shifting something that is a reasonable standard. I think for our district attorneys. We just heard Mr. Cook testify to something that's almost an unmeetable burden, which I would hope that small businesses would also be concerned about. Crime, diminishing property values, crime breaking into their businesses,
Sure.
crime and gang members killing people on our streets, drugs impacting their workforce, and I'm really disappointed to see y'all's position on this.
Another question, Representative Welch.
My question is for Representative Turner.
You can ask him. That's
Okay.
fine. Push that mic over there, Nathan.
Thank you, Mr. Chairman.
Yeah.
Representative Turner, is it not true that the clear and convincing standard is the intermediary standard that we use in the judicial system? It's not the highest level of standard, which would be beyond a shadow of a doubt. Is that not correct?
That is correct. And also to address one of the questions earlier, or one of the statements that I made that I believe to be an error, that this is an unmeetable standard. This is matching federal law, and the federal standard is clear and convincing. We do not see any lack of civil asset forfeiture cases at the federal level, so this is not an unmeetable standard. We see this used every day for civil asset forfeiture proceedings in this country.
Any other questions, Representative Welch? Ms. Turner, do you disagree with the district attorney that testified that if we did this, we'd be the only state in the nation that used this standard? And the federal government?
I don't believe that is the case, because federal government has the local sharing aspect. They require this for federal cases, so any state that is involved in federal cases would have to adopt this for those federal cases.
No, my question was, as I understood, that our district attorney, he said that he didn't know of another state that used this standard. Is that, maybe, did I misspeak?
I think there may be some, but the overwhelming majority
Okay, I
use our
gotcha.
clearing standards. It's 31 states.
31 states use
31
preponderance of the
states.
evidence and the federal government. That's what you said.
The material I was given said the federal government uses preponderance. I know that 31 states do, and the briefing I got before this, I didn't know I would be here till just a little bit earlier.
Okay,
But
thank you.
I do know that 31 states use this, and I will say that clear and convincing in Georgia is only used when you're going to take someone's child away. That's the only civil case where it's currently used.
Okay. All right, I don't have anybody else signed up at this time. So without that, we'll bring the bill back to the committee. We appreciate you being here today, Ms. Humphries. Is there a motion regarding House Bill 969? There's a move to pass. Is there a second? There's a second. Did you want to speak, Representative? Did you have your? Okay, all right. Any discussion? Hearing none, all those in favor of the do pass motion of House Bill 969, please indicate by saying aye. Those opposed?
No,
All right, the ayes have it. You'll pass. Yes? Mm-hmm.
Mr. Chairman, I would ask that we record the yeas and nays.
Okay. All those in favor of House Bill 969 will indicate by raising the right hand. Ms. Oliver, Mr. Welch, Mr. Dryer, Mr. Holt, and Bruce. All right. Those opposed? All right, Mr. Kelly. All right. You passed the rules.
Thank you, sir.
Yeah, huh?
Thank you.
Mr. Nimmer, which one of your three would you like for us to call first? All right, come on up. Come on up. We'll start with House Bill 808. Good to have you, Chairman Nimmer. Please tell us about House Bill 808.
Yes, sir. Thank you, Mr. Chairman, members of the committee. House Bill 808 was brought to me on behalf of my Waycross Judicial Circuit, our Chief Judge down there, Dwayne Gillis, and his team brought this to me. I will tell you, I have three bills, as the chairman mentioned. All three bills have been have gone through county commissions that encompass the 6 county districts. All have written letters of support for what we will discuss here, and all 6 legal organs have run these efforts in their paper, and we've got to really consider. House Bill 808 just simply seeks to change the date for their calendar and when they will hold court. It's just that simple, sir.
Okay.
Thank you.
Okay. I don't think we have anybody signed up to testify, and Representative Aller likes your bill. So, and so simply all we're doing is just the judges have gotten together and decided when they need to change some of their start dates. That's right.
Yes, sir. That's
Okay.
correct.
Okay, good enough. All right, there is a, I don't see any questions, so Representative Aller has a motion to pass. Is there a second? There's a second. Any discussion? All those in favor of the do pass motion for House Bill 808, please indicate by saying aye. All opposed? All right, House Bill 808 is done. How about we do 986 next?
Okay, sir. Thank you, Mr. Chairman, members of the committee. If I could draw your attention to House Bill 986. This is a stipend increase for the judges in the Waycross Judicial Circuit. Again, all 6 county commissions have signed off on this. Letters of support from all 6. Ads run in all 6 legal organs. The DAs, everyone in the circuit is in favor of this.
In other words, the amounts on line 20 through 25, that's what each county is paying as is that monthly?
Yes,
Or
sir.
is
That's yes, sir. Per
That's
month.
monthly, okay. Excuse me. All right, any questions from members of the committee regarding House Bill 986? Ms. Oliver?
I must be wrong about this, but I feel like, in remembering what Chairman Willard did, that we eliminated local supplements.
Here's what I think we did on that. We capped them at a certain level, and Judge Brown is sitting over there, can help us. So if you're below the cap, you can raise them. Yeah. So if you're below that, I think you could raise it. Judge Brown, go ahead and tell us who you are and where your circuit is. I should have introduced him earlier. He's with us today.
Thank you, that's really helpful. I know DeKalb is capped.
Yes, ma'am.
That's the reality.
And I think Augusta is too, so,
Yeah,
yeah.
yeah,
It's prejudicial against us is what it is, and it's all, so.
thank you.
You want us to change that while we're here today, Mr. Nimmer?
I just want to pass House Bill 986.
You don't want to open up that can, you don't want to open up that can of worms? Okay.
No, sir, I don't.
Okay, good enough. All right, any other questions from members of the committee about Representative Nimmer's House Bill 986? It is good for them to be working together like this. I think it's a good thing. Representative Welch, you had a question?
What's the fiscal impact of this bill on the state?
I don't know the answer to that.
Mr. Chairman,
Mm-hmm.
I don't know how we can pass out a bill without knowing the fiscal impact of this legislation
This
on
is,
the
this is the
state.
county's paying this supplement, sir.
There we go. No fiscal impact.
You got to put
Chairman
him,
Welch, I'm a little bit tired. We met mighty early this morning.
you got to put him on retainer, and he'll be more nice to you, Mr. Nimmer. That's
Well,
what you
I
gotta
do pay him. I
Yeah.
just don't pay him enough,
Oh,
apparently.
okay, all right. Evidently, he needs a raise in his supplement. That's what
He'll
it,
get it
okay.
if he votes yes.
All right, okay. All right. Okay, all right. There's a due pass by Representative Oliver. Is there a second? Second by Representative Welch. Any discussion? All those in favor of House Bill 986 due pass motion, please indicate by saying aye. Any opposed? All right, Mr. Nimmer, you are off the rules also on House Bill 986. Now your last one, I believe, House Bill 812.
Yes, sir. House Bill 812, and this is it started off as a Waycross Judicial Circuit bill, and it ended up being after we went through Legislative Council and our judges came back, and I guess talking with other judges in the state, they decided to make this a statewide bill to add the magistrate courts in with the law library fees of $5. It is my understanding, and I don't speak lawyer very well, Mr. Chairman. I speak logger. and that gets me in a little bit of trouble in this committee at times, but it's my understanding that the desire, especially in my area, is for the magistrate courts to be contributing into that law library fee. A lot of our rural courthouses have needs of upgrades of furnitures and different things that those funds can be used to purchase. And my circuit is in favor of this, and I hope that the will of this committee is to move it forward.
So, Mr. Nimmer, as I understand this, and you can add in this, and I see other lights, so other members will have some comments also.
Yes, sir.
We have a $5 fee that is charged in filings, I believe,
Yes, sir.
for a library fund, and this is the public library that's maintained, I believe, by every county. No? Representative, you want to correct me on that?
I think that
Press your button there, Representative, so I can.
what you need to explain to me is how the 159 county courthouses have changed their definition of libraries, because they've moved away from books, pretty much, I think. And yet they're using them for furniture and other courthouse costs now, and I need an update on that.
I can't give you the actual definition that all 159 counties use, Representative Oliver. I just simply came on behalf of my judicial circuit and a recommendation that they had pulled out with their peers in the state, and this was a measure that they brought with unanimous consent from the folks that are engaged in this judicial practice here.
I'm also just trying to figure out, we did raise the magistrate civil jurisdiction limit to 25,000.
There's a bill to do that. I think it's the rules.
Okay.
Yeah.
So we might or might not do that.
Yeah.
But that was having a significant cost impact, taking money away from the state court in DeKalb, and now we're giving money to a library that doesn't exist. So
Well, actually, if you have less filings in Superior Court because you raised the jurisdictional limit of Magistrate Court, you just took away this $5 fee from Superior Court. So I suspect you're, in some extent, replacing it by putting it in the Magistrate where more cases are now. Now, that's the logic that I'm thinking through in my head. I could be wrong on that. I know Representative Welch is very smart on this issue.
And
in his
he'll figure
budget.
it out.
He wants to talk to us about it. Yeah.
That's great.
Yeah.
Thank you, Mr. Chairman. I appreciate the accolades, but they're not really true. But no, but to Representative Oliver's point, law libraries are, some of they still purchase books and they still maintain books. They also have and pay the Lexis or Westlaw fees to maintain computer systems for people to access and research. So there still is a traditional element and a slightly modern element to law libraries, but I don't disagree that the definitional use or the use that's allowed under statute for law library proceeds from this particular fee is broader than just books and LexisNexis and those things. But my question to Representative Chairman Nimmer is so you're telling us that your judicial circuit took you out to the woodshed and sent you here to Judiciary?
Yes, sir. They wanted me to get a higher education while I was up here, and they felt this was the best way to do it, to be in front of this august committee.
Okay. Well, I see that.
August
No,
committee.
and
I thought it was February.
well,
August,
and-
July, whatever. It's hot, I can tell you that.
and
Alright.
isn't it true that on the law library there's magistrate representation? Is that,
That is, yes, sir. That is true.
so in a way that having them chip in, I think would be fitting for them to also be able to weigh in on what fees that are collected through the magistrate courts and then applied to the law library expenditures.
Yes, sir. Now that was part of the conversation, the way it was explained to me.
Okay.
Thank you for bringing that up.
And I
Thank
know, Representative Oliver, my magistrate judge in my county is the keeper of the library, so to speak, and he has several computer terminals, access to LexisNexis, and I guess we still call it Westlaw, and then he has several horn books that he purchases. So
Behind that pole, but she might not be in the room. I'm just trying to figure out what kind of windfall this is in DeKalb County for tens of thousands of cases.
well, I guess it would be how many ever magistrate
Right.
court takes home times 5. So I'm looking through it. I don't see exactly any place where we are excluding any sort of case that would be filed in magistrate court. So. Ready? Okay. All right. All righty. Mr. Chairman, the bill that we have in front of us now is Representative Nimmer's House Bill 812. It is a bill that would add a $5 fee onto the magistrate court filings for the law library system that we have in the state. I think it started out as a local issue that your folks wanted you to help with, and then I think through legislative council you must have determined that it needed to be done statewide if we were going to do it. Is that are you 44? You're 41. Okay. You didn't talk with Mr. Talbert. Okay.
I did not.
All right. But anyway, that's what the discussion was with you, I assume,
Yes,
that
sir.
it needed to be done
That's
statewide.
correct. Yes, sir.
Okay.
That is
Okay.
correct.
All right. All right.
When given the chance, I like to help everybody.
Understood.
Yes.
Appreciate that. I don't think we had anybody signed up. Help me if I missed it for this particular bill. Any other comments or questions from for the author? Okay. Thank you, Ms. Nimmer. We appreciate it, Mr. Chairman. Is there a motion regarding House Bill 812?
Not all at once now.
There's a motion and a second. Any discussion? Hearing none, all those in favor of do pass House Bill 812, please indicate by saying aye. Any opposed? Ayes have it. You're off to rules.
All right, thank you, Mr.
3-0,
Chairman.
Mr. Chairman.
Yeah.
Nimmer?
Thank you,
Good
Mr.
day for you.
Chairman, and members of the committee. Appreciate it very much.
All right. Thank you, sir. Here we go. You ready,
Thank
boss?
y'all.
Okay, we're gonna get in some heavy business now. Is Mr. Efstration? He's not here yet? Okay. You wanna hold it up till he gets here? He'll be presenting it. Ms. Hanson, you ready to go? Let's do House Bill 904, which is in your folder as LC 297866. Let me turn your mic on if you, there you go, all right.
This bill amends the Recreational Property Act. The purpose of the Recreational Property Act, found in OCGA 51-3-20, was to encourage property owners to permit the use of their land for recreational purposes and provide limitations on liability to encourage such use. However, the plain language of the statute has been interpreted by Georgia's Supreme Court to create unequal users of recreational property under this act. This inequity is demonstrated in the recent Supreme Court decision that came out in January in the case the Mayor and Alderman of Garden City versus Harris et al. The facts of the Harris case are as follows. In 2012, the Harris family attended a youth football game at Garden City Stadium, a facility owned and maintained by the city of Garden City. Don't make me say that a couple times fast. For the football game, the stadium charged $2 per person as admission, but the children 6 and under got into the game for free. At some point during the game, Riley Harris, a 6-year-old daughter of the Harrises, slipped and fell between the bleachers, and she fell about 30 feet and was seriously injured. Her parents sued the city to recover for Riley's injuries, but the city moved for summary judgment, relying on the immunity provided by the Recreational Property Act. The city's argument was that it was immune from liability because the child was not charged and did not pay an entrance fee, despite the fact that her parents had paid said admissions fee. The Georgia Supreme Court has long relied on the General Assembly to say what it means and mean what it says. Thus, the court, based on their natural reading of the plain language of the statute, held that only a person charged an entrance fee has the legal status of an invitee, and the statute specifically and unambiguously references any person who is not charged a fee to use the property is not owed the same duty of care by the property owners. Due to the Supreme Court's ruling on the language of the statute, 6-year-old Riley was unable to recover for her serious injuries. So my reason for bringing the bill is when attending a public event, all attendees' legal status should be treated the same. This bill creates uniformity among event goers. A property owner can still run a promotion such as kids under 6 get in free, but such as in the Harris case, when someone is paying and the property owner is benefiting, then all event goers should have the same invitee status. Please note that the language of the bill actually limits it by day. For example, if a park has a free event on Monday, then it is protected by the Recreational Property Act. But if a park has an event on Tuesday, where some or all event goers are actually charged admission, then all event goers have the same legal status of an invitee that day. So basically it provides parity for patrons.
All right, let me, we've heard from the presenter. Are there any questions of Ms. Hanson by members of the committee? Let me ask one question. You mentioned the last part, and I'm looking at the bill. It's a good exception if you have a day event that is no charge for it, then a week later you have another event and you do charge for it. You're saying that would work as an exception. Where would we find that language?
That's in line 9 where it says on a date. That's restricting,
okay.
Yeah.
All right. And one of the things we might just state it for the purpose of everybody's understanding, we've, I think, zealously guarded the ability of parties to get what we call statutory exemptions of liability. We've had several things come up before this committee in years I've been here, and we make sure that if there's something being done as an enterprise, I'll call it, a pay-for enterprise, we want to be clear that that is something that they need to be recognizing that if they wrongfully harm someone, negligently, but maybe a better word, then there may be a liability. And we try to be sure that those who do it on a basis of either charity or without payment may have the coverage, let's say protection from the state on the liability question. Does anyone in the committee, I'm sorry, in the audience wish to address the committee on House Bill 904? Yes, sir. Mr. Clark, come up, identify yourself and who you represent.
Thank you, Mr. Chairman, members of the committee. I'm Bill Clark on behalf of the Georgia Trial Lawyers Association, and we wholeheartedly support Representative Hanson's bill. The court did not get it wrong. The court got it right. The straight reading of the current language says if you didn't pay, you don't get to recover. And little Riley didn't pay, nor did her parents pay for her. But as Representative Hansen says, we're talking about there ought to be parity between this patron who paid and this one who did not. If the property owner is making money that day, then they should not get the immunity. The immunity is used to entice a property owner to make the property available to the public at large free of charge. And if they're charging some and not others, they should be disqualified. According to the public policy, they should be disqualified from the immunity. And so this bill fixes that, and we believe that it does it correctly and adheres to the original purpose of the Recreational Property Act. Glad to answer any questions if there are, Mr. Chairman.
Are there any questions of members of the committee? Mr. Clark? Yes, ma'am. Ms. Hanson?
I don't have a question.
Oh,
My
I'm
thing
sorry.
won't turn off.
Okay, I got y'all.
Thank you, Mr. Chairman, members of the committee.
Thank you. Anyone else wish to address the committee on House Bill 904? If not, we will close off further public comments. The bill is now in the breast of the committee. The chair will entertain motions. We have a motion to pass. Is there a second to that motion? There is a second to it. Is there a discussion on the motion among the committee? If not, are there any amendments to be proposed? There being no amendments, the chair will call the main question, which is a do pass motion. All in favor signify by saying aye. Aye. Opposed, same sign. Motion carries. Thank you. Ms. Ballinger, I'm going to let you get your bill up before we get to the lengthy part of it. Good afternoon.
Thank you, Mr. Chairman. I appreciate it. Ladies and members of the
I'm
committee.
gonna call up your bill first.
Okay.
This is on House Bill 834. We're looking at LC 297961. Yes, ma'am. Go ahead. Excuse
Okay,
me.
all right. And as all good bills do, as they work through the committee, it's gotten enhanced several times. And the first one, Section 1, is one of those enhancements. It has to do with temporary protective orders and extending the period of time for the temporary protective orders. Section 2 just basically allows somebody who is a victim of family violence to break a lease. It also allows for if the temporary protective order has been obtained through an ex parte hearing with a judge, then it also requires a police report. Section 3 has to do with the whenever you're terminating the lease, some of the conditions of terminating the lease. That was the language that was requested by the Apartment Association. And I'll be happy to answer any questions. I'm sorry I kind of went through it really quickly. And Judy Non-Civil, if it's gone through subcommittee, we kind of go through that. So I'll be happy to answer any questions or go through it more exhaustively.
Maybe we can aid you in this way.
Sure.
This bill, we had another bill, which was Mr. Holcomb's bill.
That was substantially similar. That's correct.
You say by substantially, can you point out where there may be differences in the two bills?
The Section 1 is different in that it has to do with the temporary protective orders and extending the time for that.
Okay.
The second difference, let me, since we added some language, the line numbers are a little bit different, so it might take me just a moment, but it allows for family members if a relative is incapacitated. That language is in there, and it also allows for, while not removing from the marital estate, it also allows for a refund of the security deposit, which would still be subject to marital. Oh, it's not? So that's not in there. I thought it had stayed throughout the process.
Was that something done? Whose subcommittee? Did
it was the Kelly subcommittee.
Kelly
yes, sir.
Subcommittee. Okay. Was there a discussion about that in subcommittee?
That was in what I was still presenting yesterday.
Okay.
So that provision had still been in there relative to the return of the security deposit, if in the event. But if I know time is running low, and I would be happy, Mr. Chairman, as you're also a member of Rules, to offer that addition in Rules, if that so please the chair, just to recognizing that crossover day is upon us.
Well,
so
we'll look at
those
that.
were the substantive differences.
All right. We'll look at that then.
Okay.
Something to be considered.
Okay.
But we have before us the current bill, which is LC 297961. Are there any questions of members of the committee of the presenter? Yes, ma'am.
I'm trying to put section 1 together with the bill that I think came out of this committee that extended the time
It
to
did.
serve the protective order for 45 days. What happened to that bill? This is different than that bill. That was Ms. Hanson's bill, I think. Did that ever proceed anywhere?
Yeah, Mrs. Hanson's, Representative
section
Hanson's
one?
is section 1.
Okay, that's what I.
All right, anything further? Anyone else have questions of Ms. Ballinger? Well, thank you, ma'am. We're going to see if anyone in the audience wishes to address the committee. Do we have anyone on the audience who would like to speak to the committee on House Bill 834?
Mr. Chairman, as you're well aware, I had extensive, whenever we had a hearing before the vote yesterday, whenever we had the hearing in Kelly's subcommittee, I did have extensive testimony taken at that hearing.
Right.
But I did not have anybody from the either Georgia Commission or the Georgia Coalition to
Very
come
good.
and speak today.
Thank you. If we have no further public input, we'll close that out, and the bill is now in the breast of committee. Do we have, the chair will entertain motions. Do we have a motion? Yes, sir. Discussion? Yes, sir.
It's
Is
just
this among the committee or of Ms. Ballinger?
of you. Just a
Okay,
procedural question.
all right.
Because of the close similarity between these two bills, is there going to be some merger of these bills? Or
No, sir. They will both be in rules, and it'd be up to the Rules Committee if either of the bills go forward at that point in time.
Okay.
That's as I understand it. Mr. Welch?
Move to pass.
Oh, you got a motion to pass, all right. Any further, did you have a question?
No, sir.
Okay, we have a motion to do pass. Any further discussion on the motion? Are there any amendments? There being no amendments, the chair calls the main question, which is a motion to do pass. All in favor of the recommendation signify by saying aye. Aye. Opposed, like sign. Motion carries.
Thank you, Mr.
ma'am.
Chairman. I'm back to Judy Non-Civil. Thank
Yes.
you. I appreciate it.
Yes, indeed. Now, I don't have Dempsey's here. Mr. Estration, come forward, please, sir. Glad to have you with us. And we're going to take up first the Sovereign Immunity Bill, which is House Bill 791 in your folder. And we're dealing with the latest draft of that was LC 297952. I'll find mine. So what we have is a bill that is a combining bill of two other bills, and it's your bill 791 that is being used as the main bill, and then I had filed earlier a bill that was dealing with the local governments on sovereign immunity, and that was a different bill number, of course. But it has been now combined, and what we're dealing with is the version is LC 297952S.
Yes, sir.
Like to present it?
Yes, sir. The Court Reform Council made certain recommendations. It's my understanding this was part of some of the recommendations that resulted, at least the bill as introduced, 791. Mr. Chairman, the chairman has made several changes to this bill, and even as I understand it, has the potential to continue to be amended. At this point, I cannot offer an opinion either for or against it. We would take a neutral posture and understand understanding the chairman's desire to
Okay.
add his bill to this one.
All right. Let me just follow up with your comment about that. What we basically, I did is in trying to combine the bills, I had concerns about the notice, anti-litem, I'll call it notice, that we had in the bill, and I thought that would be very cumbersome trying to work with if somebody had a potential immediate harm occurring, wanted to get some redress before the court, to have to send out a notice and then having to wait some statutory time, which I think the bill called for 30 days. We changed that to allow really for proper service to be made as a way of being sure the state was correctly notified, and that would be through the Attorney General and the individual who had oversight of that particular section of the state government. I'm trying to find the language right quick where that was. Get past, it's all in part 1. Yes, look at section 86, which is 50-21-55, says no suit containing a claim that challenges a state statute on the basis that it violates the Constitution of Georgia or the Constitution of the United States shall proceed in the courts of the state until plaintiff provides the court with proof of service upon the Attorney General or his or her designee and the state government entity that is charged with enforcing the state statute being challenged. So whereas the original bill had a notice going to them, we're requiring service, and that service has to be proven before there can be a court hearing. That's the only really substantive change that was put in by me. And I know we had some discussions about that.
I understand the concept there very well, and I'm not speaking in opposition to that provision.
But the main thing we have as far as another, let's say, difference is the provisions of the state sovereign immunity address only a constitutional challenge to a statute, whether it be state or federal challenge in a court of, as far as a state constitutional provision or a state statute, correct?
Yes, sir.
You want to talk about that and what went into the determination?
Well, there's case law, recent case law that would restrict or prevent such actions from occurring, and Georgians should have the ability to seek such relief.
All right. The second part, which is beginning on line 92, page 4, this is where we now have what was the bill dealing with local governments, my bill, that was added to this. And much of this language comes from the bill that we had 2 years ago. That took 2 years to get through the legislature, but that bill provided for all government, both state and local governments. We have now the governor's proposal, which is a state section, and I've taken just the provisions that we have for the local government in part 2 and left pretty much the language the same as it was heard by this committee at that time. It's a somewhat broader. It just says, of course, sovereign immunity of the political subdivision hereby waived as to any claim that is brought by an aggrieved person in the courts of the state. I'm reading from lines 103. Brought the courts of the state by an aggrieved person against a political subdivision seeking declaratory injunctive relief to remedy an injury in fact caused to such person, including an imminent threat of injury to such person by a political subdivision acting without lawful authority beyond the scope of its official power or in violation of the Constitution of Georgia, the Constitution of the United States, a state statute, or local ordinance. So that was the main section where we have two different ways of looking at it. And we've defined political subdivision means a county, municipal corporation, consolidated government, or school district of this state. So that's why we have the difference to it. We go to section 2. That is just to recognize where sovereign immunity is addressed in Code Section 3633(1). The sovereign immunity is of a municipal corporation shall be waived as provided in that code section I just read out loud. Then we have an area that we had from the previous bill that was asked for by the Attorney General's office. I don't know if we have anyone here today from the Attorney General's office, but they have oftentimes what we call quiet title claims brought that name the state as a party. And rather than having the state, once it reviews it through the Attorney General's office, comes to determination, there's nothing here for us to present as far as a claim to the property or funds. They don't need to file anything, and so they want to be recognized, but they're not filing anything, that they were not negligent in their duties as Attorney General. So we said when the Attorney General does not file a responsive pleading to an action filed pursuant to this part, the court shall accept this state's acquiescence to the petitioner's claim for relief. So that's just to be sure they weren't viewed as being negligent in that conduct. I think we got some. You want to ask of the presenter a question, or you want to discuss? Huh? Okay, we will. You want to get out of here, you tell me? Did you have a question for the presenter, or do you want to talk about it? All right.
Representative Administration, did you have a chance to look at the amendments that I put on your desk earlier today?
Just briefly, but I'm not prepared to. I'd need a copy of it to speak with you about it at this point.
Okay, but I gave you a copy earlier today,
Yes,
right?
sir.
So
And I have it electronically. I can look at it here.
Okay.
But,
all right. But did you have any? But you don't have any thoughts on it at all? The amendments proposed?
No, I would just refer to my earlier comments as
Okay.
things stand, and there have been multiple iterations of this bill at this point, and so I'm not here to speak against the bill,
Right.
but I cannot speak in support of it until a comprehensive review is taking place.
Okay, thank you.
Did you have a question of the presenter, Mr.
Well, Mr. Chairman, it is about something you discussed, part 3 of the bill. Should I wait
Okay.
now and ask
Hold
you
that
that? Or
during-
hold that?
We'll
okay.
get to
All right, yes, sir.
discussion on the committee, and Ms. Oliver
I'm sorry, are we asking questions?
of the presenter.
Forgive me, I'm not sure I remember whether or not, lines 149 and 155 have been discussed previously in this committee. But clearly there are actions for injunctive or declaratory relief where attorney fees, parties entitled to attorney fees. And I'm trying to figure out if this is intended to deny attorney fees in successful injunctive relief cases.
We'll get to the discussions among the
Okay.
committee in a moment. If no further questions of Mr. Administration, thank you, sir. Is there anyone who would like to address the committee on House Bill 791? Mr. Clark. You can come up.
Chairman, we stand in support of the bill, as we've said on a couple of occasions, and you've heard my concerns and discussions, and I understand where the bill is going. I really want to speak today only if I hear in the halls that an amendment, perhaps by my friend Mr. Fleming, is going to be offered dealing with a related issue, but one that hadn't come up before, and I'd like to be heard on that if he is going to offer his direct appeal amendment.
Oh, yeah, okay. Excuse me. We're going to go into it in a minute, yeah. Anything else you want to
May I
address?
be heard on that?
Yes, sir.
All right, thank you,
Certainly.
Mr. Chairman. This amendment that Representative Fleming will be offering is essentially House Bill 256 that has not moved yet, and it gives the government a direct appeal, a right of direct appeal, if their motion to dismiss or motion for summary judgment based on an immunity defense is denied. and they will get to go directly to the appellate courts, stopping the case dead in its tracks for however long that may take. That's a good judicial economy idea. I understand where the representative's coming from. But there's a related issue, and that is that the government gets to use the immunity defense over and over and over in some cases. For example, under the State Tort Claims Act, I believe there are 11 or 12 exceptions to the waiver of sovereign immunity. And so, and this is not a hypothetical, these cases happen frequently. The government moves for summary judgment based on one of those defenses, one of those exceptions to the sovereign immunity waiver. They lose at trial court. It goes to the appellate court, the Court of Appeals. They lose there. They seek cert, and they go to the Supreme Court and lose there. The case comes back to the trial court. They then move for summary judgment again based on exception number 2 to the State Tort Claims Act, and on and on and on. And that is hardly consistent with the efforts at judicial economy that Representative Fleming's amendment would seek. And so we would like to ask you to consider language, and I'll be glad to distribute it if you care to have me do so, Mr. Chairman, that would essentially be a one bite at the apple rule. And that is to say, you get your direct appeal, but as a condition precedent to that, you have to have raised every immunity defense you're going to raise in the case at that initial motion so that the court can rule on it, the appellate courts can rule on it, and the case can either be over or the case can be back to the trial court where the plaintiff can get their right to trial by jury. So I would suggest that that would be a balanced approach. Representative Welch and I had a conversation earlier, and I'll just tell you that there are those who say we as the government get to raise an immunity issue anytime we want to, and that until all those immunity issues are disposed of, we get to keep raising them. Well, I don't disagree with that, but I think there ought to be one bite at the apple. Raise them all now or waive them. There's a statute, I want to say it's in Title IX, that essentially says if you've got defenses and you're raising a motion, you got to raise all your defenses now or you've waived them. That's similar to what I'm talking about here. Is I think the state ought to be able to raise all the immunities available to it, but they ought not be able to use the litigation strategy of up to the appellate courts and back, and up to the appellate courts and back, and to delay justice and delay resolution of the case. If you're interested, I'd be glad to submit language to you for consideration, but I appreciate being heard. I'm glad to answer any questions, Mr. Chairman.
Are there any questions? Mr. Welch.
Thank you, Mr. Chairman. I don't disagree with what Mr. Clark is seeking for the purposes of judicial economy and not gaming the system. But with that being said, I just wanted to clarify, because my understanding of the case law in this area is that the sovereign immunity is not a defense. It is a jurisdictional prerequisite, and that it is the burden of the person or the entity saying that it has been waived to set that forth in their petition or complaint, to prove that to the court that it in fact has been expressly waived, and thus the burden is on the person challenging the state. Otherwise, it is presumed to be there, and of course can be raised at any time. So then that would necessarily, the amendment would then shift the burden to the state to determine all of those issues and assert them all at once. So you're changing the dynamic that has historically existed in this area of the law. And I know that Mr. Ramsey is here, and he can either tell me I'm wrong or right, but I have dueled with Mr. Ramsey in court, and he is very schooled in this area of law.
Well, if Mr. Ramsey wants to come up and address the committee, that's his prerogative.
Thank you.
I would, if I may respond, Mr. Chairman, I think Representative Welch is exactly right, but I believe it's within the power of this legislature to change that. And you could do so by simply making it a condition precedent to their having the direct appeal, that they first have raised all of the immunity issues that they intend to, and if they don't, then they would be deemed waived.
You want to follow up anything else, Mr. Welch?
Yeah, I think we'll just have to. It's going to be a little bit of an experimentation because of the nature of the waiver. We would be statutorily waiving sovereign immunity if the local government attorney or state attorney did not raise all the immunity defenses then therefore they'd all be waived after that point. So
Mhm.
just, it's a big step.
Well, yeah. And I believe, of course, don't know all the law by any means, but I think defenses are always open to be raised if you have a defense until you get a pretrial order by the court. There are some that you have to raise initially. I think, are those affirmative defenses?
Yes, sir.
So otherwise than affirmative defenses, you're open to having the ability by law in a way to raise. Of course, we're talking about changing the law if that's your amendment, in effect. All right. Thank you, sir.
Thank you, Mr.
You
Chairman.
want to say
members of the
something,
committee.
Mr. Fleming?
Mr. Chairman, thank you. Representative Welch, I was following what you were talking about, and I'm thinking I have my mind wrapped around it, and I want you to see if I do. Subject matter jurisdiction of a court can always be raised, because subject matter jurisdiction goes to whether or not this court can even hear this claim. That's why it can never be waived. It can always be raised.
That's jurisdiction.
What you have said is that the issue of sovereign immunity is, in a sense, like subject matter jurisdiction, because the court does not have the jurisdiction to hear the case if sovereign immunity applies. And therefore, if we accepted, I think, the change that Mr. Clark was talking about, we would change that law, basically. Okay. I just want to make sure I had my mind wrapped around it. Mr. Chairman, I'll let you decide the appropriate time, but Mr. Ramsey is the cause of all this trouble by bringing this to me, but I sincerely appreciate his efforts. I'd like to have him come forward and address it, but you tell me when the right time to do it is.
Well, we're going to do that in just a second.
Okay.
And we're going to go further public comments. Mr. Ramsey, you want to make a comment to the committee about your suggestion?
Thank you, Mr. Chairman.
I'm going to have to see where you can get the mic in.
I talked enough a couple of days ago. I didn't plan on talking today, but I do want to speak to this issue about the direct appeal and say I agree with my longtime and previous opponent, Mr. Welch. We're all on the same side now on the issue. And as Mr. Fleming, Chairman Fleming had indicated, it is very clearly a subject matter jurisdiction issue. Mr. Clark referred to some defenses that have to be raised initially or they're waived, and that's true. Issues like improper service of process, those, if you don't raise that initially, you lose it. But the courts have been very clear that sovereign immunity is a subject matter jurisdiction issue. A couple things I want to follow up on that on the why is this the right place to put this bill. From the beginning, as the chairman indicated, the whole idea behind this legislation was to undo several Supreme Court cases in the last few years, since 2014's Sustainable Coast decision. Now, I'd say that that's probably accomplished as to the new part, the chairman's part of the bill. It's the state portion that wouldn't change the outcome of Sustainable Coast or some of the other cases. But be that as it may, and the quiet title part of the bill as well, that is also in response to a Supreme Court decision. This issue is as well. Prior to 2016, in a case called Rivera versus Washington, it had long been the case that denials of immunity by a trial court were directly appealable. The Court of Appeals had said that for many years. Well, in the Rivera case, it finally got to the Supreme Court, and they said, you know, this is a threshold issue. This is a subject matter jurisdiction issue, but it simply doesn't fit the direct appeal statute. And the court went on to say, but because it is a threshold issue, we encourage every trial judge to grant a certificate of immediate review, because this does go to the court's ability to even entertain the case. Well, we've had several examples in the last couple of years since that changed, where trial courts have declined, as is their right, to grant a certificate of immediate review. And so what happens? Well, then you go on through trial, and then you raise the defense at the end of the case. Well, sovereign immunity is a defense to suit, not just to liability. And if you have to go to the end of the case to go to an appellate court on that issue, you've effectively lost much of that sovereign immunity. This amendment would simply reestablish what the long-standing law was, what we all thought the law was, just like what we thought the law was before Sustainable Coast. And I would say one point to Mr. Clark's suggestion about one time, raising this by one motion at one time, or else you're out of luck. You know, that might work for sovereign immunity. It would not work for official immunity, because most of the time in official immunity, when it's a lawsuit against an individual employee or officer of a government, that turns on whether the action that was taken was discretionary or ministerial. And usually the courts will say, we've got to do some discovery on that issue to determine exactly what type of action was taken here. Usually can't be really raised at motion to dismiss phase. And so it would be summary judgment later. So I think it's not workable to say that, even apart from the subject matter jurisdiction issue, it's not workable to say you got to raise this by a motion at the outset and deal with it then. So we, from an ACCG standpoint, the county standpoint, we strongly support adding the language of House Bill 256 to this bill. It's all related. It's all fixes to Supreme Court decisions in the last few years. And Mr. Chairman, I appreciate the time again to speak to the committee.
Yes. Always glad to have you with us. Is there anyone else, any questions of Mr. Ramsey? Is there anyone else who would wish to address the committee on House Bill 791? If not, we will close off further public comment. The bill is now in the breast of the committee. Chair will entertain motions. We have a motion due pass. Is there a second? Here's a second. Is there discussion on that motion? On that motion. Mr. Welch, you're going to talk about the motion or the amendments? Okay. We have amendments proposed. I want to do this, Mr. Welch. You've got a sheet that is numbered AM 292770, and you have several in here. And I'm going to do these by dividing them up and call them Welch Amendments 1, 2, 3, 4, and 5. Can we do that, please? So beginning at line 5 will be your first amendment. Is that right?
That's right.
All right. So we'll call that the Welch Amendment number 1. You want to speak to your amendment?
And if we could, we might add 15, 16, and 17 to that same one. It's the same language change or addition.
15. I'm sorry.
Lines 15, 16, and 17.
Okay.
So
other replacing at line 61, you're also saying it's at line 15, 16, and 17?
That's correct, yes, sir.
Okay.
So if you'll look at the bill, this was an issue that Mr. Clark had raised previously, and on line 61, it says that this article shall not apply, create, imply, or otherwise provide a private cause of action. The language modification that I propose in amendment number 1 is just to say that it would read, this article shall not create, imply, or provide a private right of action not otherwise provided in this article. So that makes it clear that this article is providing a private cause of action, and it just clarifies that language. And that's contained in line 61, and that same language is also in the local government section, section 2, at line 121.
That's a different amendment. I'll suggest we do these by specific language to that section you're talking about, then we'll get the other one later.
Okay.
So your first one deals with line 61, and you have added not otherwise provided by this article to the existing language, correct?
And struck the word otherwise in the existing language. That's correct.
Right. Is there a second to the Welch Amendment 1?
Second.
It's been seconded. Do we have discussion on that amendment? Is your not that? All right. All right. No further discussion. We'll take up the Amendment 1, Welch Amendment 1. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion on the amendment carries. We'll do Welch Amendment 2. Want to speak to that one?
If we could, Welch Amendment 2, if that would be all right with the chair, would be looking at lines 15, 16, and 17 of the written amendment before you.
Yes, sir.
Okay, and this is the same language, but it's found in section 2 of the bill.
Well, let me do this. I'm sorry. I'm going down your list.
Okay.
I'd rather keep them in that same
Okay.
order, if I might, please. So I had it starting at line 8.
All right. Line 8, if you will, line 8 through lines 14 deal with the addition of, if you look at lines 13 and 14 of the amendment, we're adding the language, a rule or regulation adopted by a state governmental entity. And this is found in the bill at line 109.
I'm looking at, you had by inserting at line 98 and 99, you get line 8 of your amendment sheet.
Yes, Mr. Chairman, but all of lines 8 through 14 all work together.
They do, all right.
Yes, sir. So if you could look at them as one amendment, I think you'll see what I'm saying. So if you turn to page, or to line 109 of your bill.
Right.
So the underlying bill, you'll see there that it talks about violation of the Georgia Constitution, the Constitution of the United States, a state statute, or a local ordinance. And all I've added in this amendment is to add the language, a rule or regulation adopted by the state. So if there's a violation of the local ordinance, the local action violates a rule or regulation of the state, that too can be challenged.
And so you're inserting at line 109 at what point?
So what, after the comma that follows statute,
Statute, okay, a rule or regulation.
it would say a rule or regulation adopted by a state governmental entity.
All right.
And for that reason, I needed to add the definition of what a governmental entity is, which is in lines 8, 9, and 10 of the amendment. And then we had to renumber.
Okay. Is everyone clear on the motion? Yes, sir. Mr. Fleming, you have a question.
Representative Welch, tell me the effect of what you're proposing again, please.
Yes, sir. So with respect to subpart or subsection B that's in the main bill, we are waiving sovereign immunity where we have a claim for declaratory injunctive relief by an aggrieved party against the political subdivision of the state. And you're able to challenge that through declaratory relief or injunctive relief where there has not been lawful authority exercised, or that's been beyond their official power, or it's been in violation of the Constitution of either the United States or Georgia, state statute, or local ordinances that's currently written. And I'm just adding that if the action that's being taken by the local government is violative of a state regulation or rule, then that would also be, you could also seek declaratory relief or injunctive relief.
Any follow-up question? So we're all clear. I'm going to give what my understanding is. You're inserting a new definition at line 98, 99, which is between those lines, and that is on line 9 of your proposal here, which is a governmental entity shall have the same meaning as set forth in Code Section 50-21-50. And that entity, that definition describes a governmental entity as what?
In that part of the bill, that definition is, it's on line 19 of your bill. Governmental entity means a department, agency, division, bureau, board, commission, authority, office, association, or committee.
But that's of the state.
Of the state, that's correct.
Are you bringing the state now in as a part of this new area that we're having set up for local government? So.
No, not bringing the state in, but if a governmental entity of the state adopts a rule or regulation, and the local government adopts an ordinance that is violative of that regulation.
I'm concerned that it may be read by those who are not in this room, what
Okay.
your explanation is, as having brought in the state by that definition of the governmental entity.
I'm not following the.
Well, my concern is we going back into the language of what is the definitions addressing the immunity of the state.
Mm-hmm.
And as you say, it's at line 5021 to 50. Let me get that definition. That section starts out at A saying sovereign immunity of the state is hereby waived as to any claim that, and then we get down to B. Is it line? Sorry, definitions before that. At line 19, governmental entity means a department, agency, division, bureau, board, commission, authority, office, association, or committee. Now that comes into play when we put state with it.
That's correct.
It's not, you don't have it over here, do you, with regards to how it is applied to the local governments?
That's correct. It would be incorporated by reference.
It's incorporated by reference, but I guess my problem as well is where do we have the type of entity that this government entity applies to as far as being a local government, which is the city, counties, or consolidated governments in school districts? How does that tie in? I guess my question is.
Let's take, for example, if a state agency of the Department of Natural Resources adopts a rule and regulation that applies to the coast and the additions of sand or the monitoring and regulation of the dunes, and a city on the coast decides to adopt a local ordinance pertaining to those dunes, that is contrary to or violates that rule or regulation adopted by DNR, then that someone could, under this amendment, would be able to challenge that in court and seek declaratory relief as to which one would control.
Can I ask a question, Mr. Chairman?
Yeah, I'm gonna follow up one more.
Sure.
So now we have that definition, and it is going to apply when you look at your amendment at line 109, correct?
Correct.
So we go to 109. Starting to read that section. By a political subdivision acting without lawful authority beyond the scope of its official power or in violation of the Constitution of Georgia, the Constitution of the United States, a state statute, then you say a rule or regulation adopted by a state governmental entity. So that's where we're using what may be as you point out, the regulation of a Department of Natural Resources as having been applied by that local government and having some questions of enforceability. Okay.
Yes, sir.
Now I'm a little clear on it. Thank you.
Yes, sir.
Yes, sir. Mr. Fleming?
Mr. Chairman, I think you clarified it, but I want to get it straight in my mind too. All Mr. Welch is trying to do is say that a local government could be brought into court for violation of a state statute, but they also could be brought into court for violation of a state rule or regulation adopted by an agency.
That's correct.
If I got that right, Mr. Chairman, you
Yes,
and I
sir.
agree upon
I
that? Okay.
I do.
All right.
So that will clear up the lines you have going from line 8 down through 14.
That is correct.
Mhm.
All right. And you will adopt that as one
It's in the bill.
full amendment.
Yes, sir.
All right. We have the Welch Amendment 2, which is lines 8 through 14.
Mm-hmm.
Do we have any discussion or questions about the amendment? There was a second to it. We'll call for the main question, which is a due pass of the Welch Amendment 2. All in favor signify by saying aye.
Aye.
Opposed, like sign. That motion carries. What's your next amendment, Mr. Welch? Welch Amendment number 3, beginning at line 15.
Yes.
All right.
Thank you, Mr. Chairman. This is a similar amendment as to amendment number 1. It just deals with a different line number 121. We have the exact same language that was in section 1 of the bill is also in section 2 of the bill. And so I'm asking for the committee to adopt this clarifying language.
Which is the language not otherwise provided by this code section.
That's correct.
Being added to it. And you make that as a motion?
I do.
Is there a second to the
Second.
motion to amend the Welch Amendment 3?
Second.
It's been seconded. Any discussion on that motion? Call the main question, which is due pass to Welch Amendment number 3. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. You have any further amendments?
Yes, Mr. Chairman. The next amendment deals with the issue of sovereign immunity being waived as to breaches of contract at the local government level. Historically, the courts, and this pertains to section to lines 19 through 31, and then also
You're asserting this at lines 133 and 134 of the bill. Is that correct?
yes, sir. Let me. I'm sorry. Let me do this separate. Line of the amendment, lines 19 through 25, as well as, and I apologize for having to break this up, but we're going to have to do it to make this work. And then lines 29 through 31 and 1 through 4 all deal with the contract question. So 19 through 25, 29 through 31, and 1 through 4 deal with waiver of sovereign immunity as it pertains to breaches of contract with the local government.
All right, tell us how I see your language as far as being a paragraph D that we're adding, correct?
Yes, sir.
Tell us about that paragraph first.
Yes, sir. Under that code section, 36-33-1 is the statutory waiver of sovereign immunity as to municipal corporations.
All right.
There is no express provision as to a waiver regarding contracts, and historically the courts have construed Article 1, Section 2, Paragraph 9 of the Constitution, Subpart C, that's to say that when a breach of a contract with a county or city, that would be a waiver of sovereign immunity to challenge or to seek remedies under that breach. The problem that the amendment seeks to address is that the states, that language of the Constitution pertains only to the state's defense of sovereign immunity. It does not expressly state that it applies to cities or counties. And then there's another constitutional provision under Article 9, subpart, I think Article 9, Section 2, Paragraph 10, and that says that only county and municipal sovereign immunity can be waived by the General Assembly. So since the court has been so strictly construing the Constitution, the policy issue I was raising here was to say, do we want to expressly amend and waive municipal sovereign immunity as to breaches of contract? If so, and if we do not, then the court may if so, then this would be the language that I would propose.
So we understand that part. I think now the next section you've got line-wise is at line 27, 28. Tell us how that relates to what you have. This goes in at line 152.
Yes, sir. That goes back to Representative Oliver's issue earlier, that dealing in a key tammet lawsuit or a quiet title suit, the Section 3-2 of the bill, in dealing with that context of a suit, sovereign immunity is waived for those claims, but it also says that sovereign immunity is not waived for any claims that deal with monetary relief, attorney's fees, expenses, litigation, cross claims, etc. And all I was suggesting we add to the end of that was that, or actually it would be at the beginning of it, but that we still could sue, you could still seek relief under Code Section 9-1514. And that language is, the chairman has put that language in at every point where we have waived attorney's fees,
Yes, sir.
except in the case where we have frivolous litigation.
That's what we're talking about.
Yes, sir.
All right. Ms. Oliver?
If I may follow up on this particular matter.
Yes.
The other reason I'm concerned about that language, I'm looking for the lines right now, 150 through 155, is it relates to claim for monetary relief, which should be covered by the State Tort Claims Act, I would think. But attorney fees and expenses, I'm trying to think of a state statute other than frivolous litigation where you'd be entitled to attorney fees.
It could be under 13611.
There are others, is
But-
what I'm saying to myself.
But this code section here, 23-3-45 is particular to the quiet title action. So this would not be an amendment to strike any other provision that would authorize or be a waiver. So we're only, in the bill, we're only addressing quiet title actions.
Helpful. And your suggestion was what?
Was to add at right after on line 152, after the however, you would add that except as provided in code section 9:15:14.
I understand now. Thank you. That's helpful.
Okay, thank you.
Helpful amendment.
Further questions?
I have a question, Mr. Chairman.
Yes, sir.
Mr. Chairman, this goes to part 3 of the bill, which is
Right.
on page 5, and I want to make sure I understood what you said to us earlier. This part 3 of the bill was something that our Attorney General requested we do, is that right?
Yes, sir.
Okay, and so Representative Welch, you're amending parts of that, but we feel it's consistent with what our Attorney General has asked us? You're not worried about bothering what he's asked us to do?
I have not reached out to the Attorney General on this particular amendment.
Mm-hmm.
So, because I didn't know that was coming from his office, but I would
Right.
have, as I've given a copy of
Right.
all these amendments to
Can
ACC.
Chairman comment on that, maybe?
Well, I think what we're doing is we're opening up a claim back against the Attorney General for frivolous litigation as a state body.
Mhm.
And I'd have some concern about that without their input, frankly,
Okay.
on that part of it.
So if we didn't want to do that, what part of your amendment would we not pass?
Well, you would not want to pass lines 26, 27, and
One is
28.
up for consideration at this time.
Okay.
Is that correct?
Just lines 26, 27, and 28, Mr. Chairman.
Okay. The first part, yeah. That's correct. Yeah, so
You want to strike
you
that?
You want to withdraw that from your
I'll
what is now
withdraw.
the amendment number 5. I'm sorry, 4. You want to withdraw that from your amendment 4, lines 26
Ye-
to 31.
Yes, sir. I'll withdraw that.
Okay. Now, what's the last line here? 30 and 31 do.
Yes, sir. That at line 165.
Is that a different subject matter?
All it does is just set the effective date for the contract breach, if language that's. This is an amendment to your effective date language on.
Okay.
That's all that is.
Question on that amendment, Mr. Chairman.
Let me do that one. You're not doing that one as part of this present amendment. That's separate, correct?
It would need to be all as one if we're going
Let's break that out. May I do that? We'll talk about, we're going to do the contract change. If that passes, then we do have this to be considered,
Okay.
first of all. Okay. So we're back to what is let me state, as I understand, Mr. Welch, your amendment will be only as to lines 19 through 25 at this point as being amendment number 4.
Correct.
That's after line 133. Everyone understand that point?
Question,
Any
Mr. Chairman?
question? Yes, sir.
Mr. Chairman, Mr. Welch, so if I understand lines 19 through 25 on page 1 of your amendments, what you're telling us is that we've always thought one could sue a local government over a contractual dispute.
Correct.
But you're concerned with the way our Supreme Court is heading because we don't expressly say that. They may end up saying, no, you can't, and surprise us again. So you're trying to prevent that from happening. Is that correct?
That is correct.
So you're not changing the law. You're just kind of preserving what we currently have.
That is correct.
Now, I noticed there on line 25, you only say municipal corporation. Does that definition cover all the local governments you want to cover?
No, that's a really good point, and trying to do this quickly with a short time frame. It does not expressly include counties in this, because this is the actual waiver for just municipalities.
But we want to say political subdivisions, which is defined in the bill as being cities, counties, consolidated governments, and school districts.
We can, Mr. Chairman, the only concern I have with that is that
Section.
the code section we're in is
Only
specific to municipalities.
3633.1.
That's right.
You do have a general government section under Title 36,
That's correct.
but we don't know until Julius tell us where we put that. You understand our question on it? Because in, yeah, section 80, 36-80 maybe, somewhere there. I will ask this, what we'll do is maybe suspend consideration on this point until we get that
That's fine.
clarified.
That's fine.
So we don't want to use Title 3633.1, we want to use 36-80, we think, somewhere in there.
Yes, sir. That makes sense.
Okay. And we'll let Julius do some searching on the computer for that point. So at this point, I'm going to suspend as to consideration of the Welch Amendment number 4. Do we have other amendments for consideration?
I do, Mr. Chairman.
Mr. Fleming.
Mr. Chairman, we had a discussion earlier about what is in your book is unnumbered language, but it's the Fleming Amendment at the top. It was a discussion that Mr. Ramsey had about the direct appeal. Would now be the appropriate time to discuss that, Mr. Chairman?
Yes, sir.
Mr. Chairman, as was mentioned earlier in the discussion, Mr. Ramsey, very wise fellow, I think, in this area of the law, last year asked me to introduce House Bill 256. That's the language that you have in front of you. My memory best serves me is that the chairman very understandably didn't want to act on this because of the uncertainness of the law in this area. We didn't know what we were going to do on sovereign immunity.
Last
So
year.
we held off, and I thought that was perfectly appropriate. Now that we have in front of us a sovereign immunity bill that is appeared to be moving and addressing the issue in total, it seemed appropriate, and I had this discussion with the chairman earlier, whether or not, at Mr. Ramsey's request, we now consider including House Bill 256 or what's now labeled as the Fleming Amendment into the bill. So, Mr. Chairman, it would be my intent to ask the committee to include that now into the bill and renumber appropriately.
Okay. All right, go ahead.
Yeah, no, what I was saying, Mr. Chairman, in light of that, it would be my intent now to ask the committee to include the language which is in the Fleming Amendment, which is House Bill 256, at the appropriate section as determined by legislative council and renumber appropriately.
It goes under the appeal section of code, correct?
Yes, sir.
All right. So leaving it to legislative council to make a decision of the appropriate placement of this paragraph, number 14. Is there discussion on the proposed amendment? Well, first of all, is there a second to the amendment? Do we have a second? It's been seconded. And is there discussion on the amendment? Does everyone understand the amendment? There's no question. We'll call for the main question, which is a due pass of the Fleming Amendment. All in favor signify by saying aye.
Aye.
Opposed, like sign. Have one no. Decision of the chair, the motion carries as amended to the bill. Juice, have you found a appropriate place?
Yes, I think we can put it in, chapter 80, the general provision regarding the county, municipal corporation of the governmental entities.
Yes, sir.
I would, create a new code section, 36-80-26, and, you say language there, but instead of using, well, instead of, using
D.
municipal corporation.
Yes, sir. We're going to change that. Yes, sir. Now, what do we want to do as far as shown here as paragraph D? What would it be? This new code section?
Sure. Yeah.
So we're going to remove D.
Correct.
All right. So under this amendment, the Welch Amendment 4, we remove D. We're changing the code section, the first line on line 20, to 36-80-26, and we will go down further and say, on the last line, where it says municipal corporation, we're gonna put instead, what do you want to say there, Mr. Julius, we defined it in the bill. Okay. We use the term political subdivision, which is what we'll use here as defined in 36-80-26. Right?
Right. So what we'll do is, in this new code section.
Well, it's in that same, it is that section, okay, excuse me.
So
Okay.
Code section 36-80-26, subsection A, we will say that, the term political subdivision, shall have the same meaning as provided. I'm sorry, this is.
Yeah, we are, well, here's the point, yeah, this is the new code section that we would get mixed up here. You're gonna be adding this as a last paragraph?
Yes, let's do subsection E. Let's do subsection E.
There we are. All right. So the 36-80-26 is the new code section we already have in the bill. We're changing the letter D to E, and we're changing the last part to political subdivision. That'd be, rather than municipal corporation, it'll be political subdivision. Is that clear for everyone? That is the amendment known as the Welch Amendment 4. Any discussion on the amendment? Any questions about it? All in favor of the Welch Amendment 4 signify by saying aye.
Aye.
Opposed, like sign. That motion carries. Are there any further amendments to the bill? There being no further amendments, Chair will call the main question, which is a due pass of House Bill 791 as amended as a committee substitute. All in favor of that motion signify by saying aye.
Aye.
Opposed, like sign. Motion carries. I see I've got my friend in the audience here, Ms. Dempsey. You want to get your bill out of the way before we get to the last big bill. Won't take long for this one. We're on House Bill 920, LC 297884. All right, you want to tell us about your bill, please, ma'am?
Certainly, this is reference to adoption records access brought by the Division of Family and Children's Services. Currently, the division must petition the courts to unseal records to review case actions involving adoptions, which is costly and time-consuming. Following the death of Kente Williams, a child
Let me
was
suspend for a moment. I'm sorry.
do we not have it?
It's not in the folder. It's not in the folder. So I'm asking you, please, ma'am, to stand aside for a few minutes,
Glad
and
to.
we'll go to the next bill that we've got, which would be the illustration bill 993, House Resolution 993. All right, sorry for the mix-up.
Thank you, Mr. Chairman. There is an amendment that's been circulated, or is being circulated, that is supported by me.
Okay.
All
To be
right,
sure, we're
this-
working on the same bill, that is LC 41 1460S,
Yes, sir.
and there's another sheet with an amendment.
Correct.
Thank you, here we go. Get it out before us, okay.
I'll give my abbreviated introduction, Mr. Chairman. In certain complex commercial lawsuits, specialized courts have been dedicated to provide expedited resolution of cases. There are pilot project business courts currently in existence in Fulton and Gwinnett counties. They've had a great deal of success. Also, North Carolina and South Carolina have statewide business courts currently. Business courts provide a number of benefits, including enhanced predictability, increased speed, improved case management, reduced litigation cost, and judicial expertise in complex commercial litigation. Additionally, business courts offer benefits to the broader court docket, offloading potentially what we call calendar clogger cases that can take a great deal of time and effort. Currently, the Metro Atlanta Business Case Division in Fulton County and Gwinnett County has provided a recent study that the average length of a case assigned to these courts is half the time to resolve a complex case as it would have been on the regular docket. Less time in litigation means lower cost for the parties. Satisfaction survey conducted in 2011 revealed 88% of respondents were satisfied. Currently, the business court only exists in Fulton and Gwinnett. However, H.R. 993 would expand it to be statewide. And this is only a constitutional amendment as I'm presenting to you, Mr. Chairman. There is no enabling legislation that's part of the recommendation as we sit here today. I understand the chair might have an associated bill, but just to give kind of a brief walkthrough here, we would have the business court established in the Constitution in the judicial branch that would provide for this business court to be in effect. What's contemplated is it would be a court for which referral could be made. The venue, I'm on page 4, venue would be statewide. May I have a copy of the amendment, please? Thanks. All right. As to qualifications, you'll see that I'm on page 5, lines 141, that it's identical to qualifications for a Superior Court judge. Also, as to the selection for office, you'll see lines 29 to 34. What's contemplated here is appointment. That would be for a 5-year term, appointment by the governor. In the amendment, if I could jump over there, this is lines 21 to 23 of the amendment. This contemplates potentially multiple judges depending on the growth of the court and staggering of terms to ensure that there'd be some overlap in time and opportunity to not make all the appointments at the same time. This is the amendment, lines 21 to 23 of the amendment. Yes, sir. Mm-hmm. And then members can see the question is written on page 8. So the final thing is we cleared up that there would not be precedent would not be set by the business court. That's made clear now with the amendment. Also, the amendment, we have a reference as to equity because that would be necessary to have effective powers. As it's been explained to me, ultimately we'd be looking at an enabling legislation potentially next session if the voters of Georgia approve this, that there would be districts or areas where these business courts would apply, that there would be framework within which parties of the court would assign cases to the business court, and there would be the opportunity for resolution there. But I can tell you that ultimately jurisdiction or venue rather would remain in the county where filed, that if a jury trial were to be necessary, the citizens of that county would sit for that trial, and that would not be impacted or changed in any way. Mr. Chairman, this legislation is, or this constitutional amendment is something that is supported by the Georgia Chamber. It is viewed as a means by which to ensure that Georgia has a legal climate that for businesses undergoing complex litigation that there can be greater certainty and expediency to resolving their cases. We'd ask for your favorable consideration. I'll be happy to answer any questions.
Any questions of
So Thank you, Representative Estration. I was trying to absorb the amendments and place it in the bill as you talked, and that's what I wanted to go into. You referenced the first part, the first few amendments at the top of the sheet that we have from you. Just tell me one more time what those do. Line
Yes,
4
so-
through 6, for example, line 7 through 9, line 10 through 11.
Right. So,
What are we changing there about the original proposal?
So
or,
what-
or the substitute we have in front of us?
yes, sir. So just to kind of have them side by side. So if you look at line 33 of the sub as
Right.
presented, that it would add business court as for judicial power.
Seems like that's just clarification this thing can exist. Is that
Yes,
all that
sir.
is? Okay.
Yes, sir, I
all
believe
right,
so.
Okay.
Same thing, 35.
Okay. All right.
Then jump to line 10 on the amendment, which is 118 of the sub. Is this is a statewide jurisdiction. Well, that looks to me to be identical.
And that's why I saw that and I was trying to figure out I'm missing something here.
The quotation marks had to go.
Quotation marks had to go. Okay. Important change.
And then on the next one's the equity that I referenced.
Yeah.
It's yes, sir. And then
So hit me with that one more time. What we're doing there.
that's
This is line 14 of your amendments.
well, as I understand it, equitable powers are necessary for the business court to follow through on.
It would make sense.
I think part of it's just a unique structure of the state constitution in terms of references to courts of equity and adding business court into those references.
So if this business court decided they need to enjoin somebody from doing something or order some kind of specific performance, we'd be making sure they'd have that power, just like a superior court does, right?
Be something that would be ancillary to their typical jurisdiction, but yes, it would go along with it.
Okay, all right, that makes sense. I wondered about that when I read it the first time, were we overlooking equity? I think we talked about that earlier, so, yeah, okay. And then the last one,
Yeah, the last is
starting on line 20.
Yes, sir. We previously discussed it would allow for the staggering of these terms because it is difficult at this point to contemplate how many of these judges would be needed, and that would all be determined by law. But if there were to be many judges, it would not make sense to have them all, his or her terms always end on at the same 5-year interval.
So it looks like and let me back up with a big question. We're working off of the LC 411460S,
Yes, sir.
which was a sub to the original HR 993, right?
Yes, sir.
And now we're amending potentially the sub.
That's right.
So what are the differences between the bill as introduced and the sub we have before us? You follow my question?
I do. I will.
Yeah.
I would have to have.
We're making a change to a change. I was wondering what the original change was.
I would have to pull as introduced to present it to you, but I think that throughout the process here, of course, my head has kind of been in Ways and
Oh,
Means
sure.
land for the last
Sure.
day or
A
two.
small
But,
bill you had over there.
Well,
Yeah.
but initially, okay, the concept of this has not really changed,
Right.
at least as I review this substitute now, and as it was originally presented to me, I believe it's only been cleanup matters have been addressed here.
All right. Well, let me, if I may, Mr. Chairman, ask a question about looking at your page of amendments now, starting with line 20, the one that talks about the terms and the appointment of the judges. I see what you're doing there. You're simply allowing us, I think, for legislative purposes in the future, to pass a general law which would stagger these terms, which makes complete sense.
Yes, sir.
But does that also leave up to us the number of these business court judges that we would have in Georgia?
Yes, sir. That's my understanding.
Okay, because it seems like we took out a good bit of stuff. As I look at line 129, there was more language in there that we got rid of. We got rid of the part that says shall have consecutive terms as long as he or she meets the qualifications of an appointment, or at least I thought we were getting rid of that and replacing completely B. Looks like we had in the sub, we have line 129 through 134. In the amendment you have, we're getting rid of what B is and replacing it with something much shorter.
No, sir.
No, we're not?
My understanding is just line 129 is
Just
being
line
replaced
129.
with lines
Oh, okay,
21
so we're
to
gonna leave in
23.
everything else
Yep.
that was in there. All right.
Mhm.
So, is it as far as this the selection of these judges? It is we've always, whenever we've created new courts, whether it be Superior Court or Appellate, the governor appoints them. Makes perfect sense to me. Discuss with me the thought process behind the fact that these judges, unlike Superior Court judges, unlike Appellate Court judges, Supreme Court judges, would never be elected in any way. Was there discussion on that issue?
Certainly, and I'll begin by saying that there are other administrative judges that we have sitting right now who sit by appointment.
Our new tax judge, for example.
Yes, sir. That's one example. We also have circumstances right now where in Fulton and Gwinnett counties, certain select judges are stepping forward to take this or being selected by their approved by their colleagues.
That's Shaw's Business Court, right? Okay.
The
Senior judges usually.
the ultimately a degree of expertise in the complex litigation issues that are to be heard and handled by these courts is of real importance. And not to take anything away from the election process, but there would be the potential for vetting and the possibility to identify judges with that expertise who could sit in this position by appointment.
And along those lines, Mr. Chairman, I know that we've talked about North Carolina as an example.
Yes, sir.
And evidently there are other states out there who do this too. Is there any consistency in how they handle this issue of appointment and election? And
I
so
don't know
forth?
that as I sit here, but I will find out and get back to you on that.
Okay. Thank you, Mr. Chairman.
Anyone else have questions?
Yes, sir.
Call the committee members' attention to another document you have, which was the bill that I filed today, which is HB 998. And this is done by me really in the form of a companion with the constitutional amendment proposal under the resolution. And what I thought would be helpful to have here is really the beginnings of what will be. Does everybody find it? 998. It's on I'm sorry, it's got LC 411473. Yours doesn't have a number on it, but
Okay, I got you.
you got that? Okay. Pardon me. But it was identified now as House Bill 998. And my thinking was to have really the beginning of a business court being handled through the State Judicial Council, who would really set up the initial operation of this for the purpose of seeing, let's say, weeding out problems, and so we're going through a trial run of how this would happen. And interesting, this is called a trial run because what you have is the ability in the Constitution now to set up what we call a pilot court provision. We did this in the past. I know of one time with the Fulton County Court setting up the family court as a pilot court. And that ran for several years under a pilot program before it was made a permanent division of the Fulton Superior Court by rule of the Supreme Court. So what we're looking to do is under this bill provide for what will be the initial startup of a business court so that the Judicial Council can really work out the problems and means of how it be handled, where we need the people to work on it. It contemplates having a central office here in Atlanta, or say in Georgia. The office of the Judicial Council, out of which you would have the individuals who are either lawyers with experience in this area or senior judges assigned to work on the cases in the beginning, and they would carry this through up to the time of having a trial necessary. They would go back to the local court where that would happen. The main purpose, what they would be doing, would be handling on an expedited basis cases around the state that qualify for the business court to take care of all preliminary issues, pre-trial issues, motions, discovery issues, disputes between parties, potential mediation, anything that comes up that has a way of trying to resolve the litigation in an expedited basis. So this is an approach I felt would be helpful. Two reasons. We often, when we have constitutional amendments, we also have the enabling legislation. We don't have any enabling legislation. But this could sort of serve as a blueprint for what can start out to be the way the court can handle these cases in the future once the constitutional amendment gets passed. So that is the essence. It's my proposal. It will be considered as a bill should the constitutional amendment resolution pass. Questions on that matter? Ms. Oliver.
Just procedurally, Mr. Chairman, so you are asking that we pass,
Time being of the
constitutional
essence.
amendment, constitutional amendment and amend to it?
Not really, no, it has to be a separate bill
Okay.
because you can't do a bill to a resolution.
998 was filed and you wish for it to be heard in
Today.
this committee to be added to as a separate bill, the discussion.
Yes, ma'am. It'd be a separate consideration on that, should
So
the
if
amendment pass.
the constitutional amendment passes, 998 will be a pilot program or will it be established statewide?
I'm sorry, I didn't hear your question.
998 provisions will be not a pilot program, but
Well,
establish the creation of a business court.
It would be a pilot program. That's what you're allowed to do. The legislation is allowed to do under the present provision of the Constitution, set up what we call a pilot court. Okay. And that's authorized, and I suggest it be helpful, I think, for people to know this is what they're looking to do as far as having a court set up. It would all change with the enactment of the constitutional amendment, and then next time the legislature meets and then acting specific legislation addressing the court. But the Judicial Council could begin now, for the benefit of the business community, operating business courts around the state.
Without the constitutional amendment, prior to the
Correct.
constitutional amendment. Then I have one question, if I may, now that I've got the
Yes,
procedural
ma'am.
right in mind, about 41-1473, which is the 998. Is the filing fee on 59 line 59 consistent with the Fulton County filing fee for the Fulton Business Court?
You know, the amount there is, I think they charge $1,000, and maybe it is the same. Okay, I asked Julius to look into the rules of the Fulton County, and that's where this provision came from on
And
that.
does Fulton County also use the special master process and then move to?
They use mostly senior judges.
Yeah.
I don't know if they've ever used I use the term special master because, frankly, we did something in the law about 5 years ago. I think it was very beneficial to the courts, and that was really expanding the use and services of a special master in litigation, primarily for business purposes. And the idea behind it, I don't think that seed has grown enough yet, but this will help expedite that also, I think. So, any other questions regarding that matter? Yes, sir.
So basically, the House Bill 998 or the LC 41-1473, kind of like a warm-up act.
True.
Get us thinking along these lines. So if the constitutional amendment
And what-
passes, then we have to enact some things, and we have some things going on we can look to.
Yes, sir. I think
All right.
have this start out through the Judicial Council as overseer and making the rules up of how it would operate could then be beneficial to the legislative body once it considers the enacting legislation authorized by the amendment.
Okay, thank you.
Mr. Coomer.
Thank you, Mr. Chairman. I just want to
to add a comment as a member of the Court Reform Commission. I think the structure is one that was well thought out in the sense that we were going to have an opportunity for the voters to tell us whether or not they wanted this particular power to be established through the constitutional amendment. And I also think that part of that thought process was we wanted to make sure we had a robust discussion on what those courts would look like in terms of the statutory framework. And I think you've started that discussion with your bill. I don't see any, as a member of the commission, speaking in that vein for a moment, I don't see any real detriment to moving both the resolution for consideration as well as the underlying framework bill, if you will, that you've put together. I think it makes sense for us to consider both those things and let both these things track forward.
All right. Any further discussion? We'll really be dealing with the resolution at this point only. And I know there are some amendments. I just wanted to go ahead and talk about House Bill 998 as a part of this process that we're looking at. So we're back to the resolution. Is there anyone else who would like to address the committee on the resolution, which is number-wise HR 993? Are you rising to do that? Come up, please, sir.
It's dinner time too, isn't it, Mr. Chairman?
Mighty close, 6:30. Have a seat. Give us your name and who you represent.
Good evening, Mr. Chairman. I'm Jason Rooks with the Georgia Trial Lawyer Association. We wanted to go on record of supporting HR 993. We wanted to thank the Governor's Office for inviting us to participate in the summer with the Judicial Reform Council. The 2 points we made during that process is both the making sure there's regionality to the courts and we do think the electability eventually of the judges is an important thing that we see with the other trial courts, and so we wanted to make sure that those points were made. But our members have participated in the Fulton Gwinnett courts and find it a good way to go. Thank you, sir.
Great. Any questions? We thank you for appearing. Anyone else wish to address the committee before I close off public input? If not, then public input is completed, and the resolution is now in the breast of the committee. Do we have any motions?
Do pass. And
motion do pass as seconded. Do we have amendments?
Mr. Chairman, I intend to offer the amendments that Mr. Efstration has asked us to consider. And of course, we have the 410339. I'd be happy to offer them in block.
I think what we could do is take the amendment, which is line 2 through 11 as one amendment.
Yes,
this
sir.
is mostly clarifying the language.
Yes, sir.
We do have statewide jurisdiction as a little bit of expansion there, but that's fine. We'll go ahead and take it as you want to offer that as the Fleming amendment. Number 1 is lines 2 through 11.
Yes, sir.
On AM 410339 EC.
Yes, sir. Have a second on that amendment? The amendment's been seconded. Do we have discussion on the amendment? Chair will call the question on the Fleming Amendment 1. All in favor signify by saying aye. Aye.
Opposed, like sign. You have further amendments?
Mr. Chairman, on down that page, we have 2 changes. I'd be happy to offer them together. Under section 4, it says on our amendment page, or would you like me to offer them separately?
I think there are 2 areas that
one deals with equity, I think the first one, and the second
let's
one.
take that one as your second amendment. Otherwise, before the business court.
Yes, sir.
All right. On the jurisdiction, and that's at lines
14 through 19.
14. We're on the bill. I'm just trying to think where we have that section on the jurisdiction of superior courts. Well, I know it is. We took out something else came to mind.
And appropriately placed in the right spot in the bill by legislative counsel. How about that?
Yeah.
He doesn't want to go to dinner.
You want to find that placement, and we'll leave it up to you.
Right. I think what we did was
I'm sorry, 19 of the bill? That's what I'm looking for, not the bill, the resolution.
Okay, it's gonna be at the line 118, it's gonna be.
Okay.
It's gonna be replaced.
All right. So you got paragraph,
Mm-hmm.
wait a minute. That's called paragraph 2 of the, I don't want to strike out a provision of the Constitution here. I'm not clear where it goes.
Well, I think what we have, if I'm not mistaken, legislative council can tell us, is that we have on the amendment from lines 14 to 19, we have a portion of the Constitution that affects superior courts.
It's not in the resolution now?
And therefore,
Okay.
we would be putting that portion of the Constitution into the resolution because
Okay.
that's where we make the reference to
I
equity.
understand.
And superior court equity would be similar to our business court
I
equity.
understand. Okay,
Yes,
so
sir.
we don't have before us in the resolution this section of the Constitution, but we're amending it by this amendment.
Thus renumbered appropriately by legislative council, Mr.
Correct,
Chairman.
okay. Is everyone clear on that? That'd be the Fleming Amendment number 2. Do we have a second? It's been seconded. Any discussion on the amendment? We'll call the question, which is a passing to Fleming Amendment number 2. All in favor signify by saying aye. Opposed, like sign. Motion carries. Further amendments?
Mr. Chairman, if I may, now with line 20 on Mr. Estration's amendment where we
Yes.
talk about the terms of the court there,
All
20,
right.
20 through 23. I think our port where line 129 is the right place to put that.
So to be clear, what we're doing here is we're just adding at the beginning of what is identified at line 129, paragraph B, the first line sentence.
Yes, sir.
And the
Replacing it.
rest of it would remain as it is stated, beginning with upon expiration of such term.
Yes, sir.
All right. Is that clear to everyone? Any questions? You propose that as amendment?
Yes, sir.
Do we have a second? Have a second to the amendment. Any discussion on the amendment? If not, call the question, which is due past amendment number 3, Fleming Amendment number 3. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Are there any further amendments? There being no further amendments, Chair will call the main question, which is a due pass to the Resolution 8, under HR 993, excuse me, as a committee substitute. Hold on just a second. All right, Learned Counsel wants me to be sure we clarify that all amendments of AM 410339 have been added to the resolution. So we're adding that in as part of the motion. Substitute, this is now a due pass to House Resolution 993 as a committee substitute. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. We will next consider, while we're on the subject of the matter of business court. Do what next? All right.
Mr. Chairman, I'd like to move that LC 41-1473 do pass as House Bill 998.
Second.
We have motion second. All in favor of the motion signify by saying aye.
Aye.
Motion carries. All right. Now, Ms. Dempsey. Sorry. I don't leave now. Best part's coming. All right, Ms. Dempsey, glad to have you with us. Sorry delayed you a little bit, but we're all staying with you.
Well, I'm going to try to do it quickly so y'all can all get on the way, too.
We're going to call up your bill, which we now have is HB 834, LC 297961.
It's 920. The bill is 920.
I'm sorry, did I read the wrong number? It says 920. My mistake. Sorry.
920.
HB 920.
LC 297884.
Yes, ma'am.
Okay. So
Short
this-
little thing.
It is. It is. We ought to be able to do it quickly.
We'll
I
amend
think.
it though.
Adoption records access. That's what we're talking about. It is a Division of Family and Children's Services bill. Currently, the division must petition the courts to unseal records to review case actions involving adoptions, which is costly and time-consuming. Following the death of Kente Williams, a child who was adopted from foster care and who died at the hands of his adopted father, the division sought access to case records to review its involvement with that family, and the access was only possible with the approval of the courts, which was granted several months after Kente's death. So they are seeking access to their own files following adoptions in two instances: when a child who was adopted from foster care is later the subject of a report of abuse or neglect, and when a child who was adopted from foster care is seriously or fatally injured. It can help save lives, improve case managers' ability to screen cases, and identify potential risks for harm based on prior history. There's a precedent for this access, and the experience has shown it is used rarely and without abuse. Access would only be granted at the discretion of the division director or his or her designee, and may be provided to the child advocate for the protection of children. And Director Pryor is here, too, if they're in need to.
She is here. Thank you. My one question is this. When we open up these files, we are not in any way changing the current exemptions of this being considered open records as to those type of files.
It is my understanding we are not. I don't know if there's someone that might.
That is correct.
Okay. All right. Any questions of Ms. Dempsey by members of the committee? We've got, Chair will entertain motions. All right, got a motion to pass, seconded. Any discussion on the motion? Any amendments? If not, Chair will call the main question, which is a motion to pass recommendation on House Bill 920. All in favor signify by saying aye. Aye. Opposed, same sign. Motion carries. Thank you. Thank you all for staying with us too. I appreciate everybody on the committee for helping out. Yes, sir. Thank you, man.